Welcome, everyone. I'm glad you're here. Please help yourself to some snacks if you haven't yet. This is Use and Disclosure of AI and IP. This is CLIC's last open event of the academic year, and I am Professor Roberts. If you don't know me, I am the faculty director of CLIC, the Center for Law, Information, and Creativity. And it's been a great year, and I'm particularly happy that we are going to go out on such a high point. So thank you to the attendees in person and on Zoom, and to Dean Huber and Voila, and of course to our lovely guests who I'll introduce shortly. So Northeastern is really excited about artificial intelligence, and the Dean of the Law School is really excited about artificial intelligence and Gen AI. I myself am wary about AI, so I do know we need to talk about it, right? As lawyers, as scholars, as informed citizens, because it's coming for us either way. So I asked myself, what brilliant minds can I invite to come before you and not make proclamations, but ask interesting questions and hard questions about AI and IP. And that has been, this is my first year as faculty director of CLIC, and it has been such a privilege to ask those questions, to say, who would I most want to hear from on this topic? So our featured speaker is Professor Jacob Noti-Victor from Cardozo Law. He teaches copyright law, property, and an IP colloquium, which puts him like exactly in the sweet spot for today's topics. Professor Noti-Victor holds an AB from Harvard and a JD from Yale. And before entering academia, he was a law clerk for Judge LaValle on the Second Circuit and an IP litigator at Kirkland and Ellis. And at YLS, Professor Noti-Victor was on the board of Outlaws. So on behalf of NUSL, we call ourselves the queerest law school in the nation. So thank you for your advocacy. Professor Noti-Victor's research focuses on how the law impacts innovation, culture, and the deployment of new technologies. And I've asked him to try to do two things today. First, to kind of update us on the current state of litigation around AI and copyright, because there's a lot going on in this space and a lot of new developments. And then second, speak to us about transparency and the question of whether the public is entitled to know when generative AI was used in the creation of an expressive work, of an artistic work, and if so, why? And the latter topic is the subject of his recent article, Regulating Hidden AI Authorship, which came out in Virginia Law Review, I think just about 3 weeks ago. So this is hot off the press. And then we have a discussant today who is our very own Professor David Stein. Professor Stein just recently joined the faculty here at NUSL and also at the Corey College of Computer Science. He holds an SB, which I'm assuming is a Bachelor of Science, but in Latin, because I have an AB, and a Master's in Engineering from MIT, and a JD from the NYU School of Law. And he's also the named inventor on 7 patented digital identity and database management technologies. And Professor Stein studies the interplay between emerging technologies and legal institutions, including, he's got a number of really intriguing works in progress right now on AI and its interplay with intellectual property, with privacy, and also with litigation more broadly. And in my experience, Professor Stein is particularly good at explaining complex technology to lay people, which is one of the reasons that I think he's a perfect discussant for today. So I'm going to hand over the floor to Professor Noti-Victor.
Great. Thank you so much for having me here today. It's so great to be here to talk about some hopefully fun and interesting questions related to copyright, AI, and public disclosure. So I'm going to start with a kind of overview of the state of play when it comes to this question of whether AI-generated works can be protected by copyright. And then I'm going to talk a little bit about disclosure and how that relates to the question of copyrightability of AI. And then hopefully Professor Stein and I can have an interesting conversation about some of the broader policy questions, legal questions that these things I'm going to talk about relate to. So one thing I'm not going to talk about, just to be clear, is fair use. And you probably, for those of you who are enmeshed in this area and the question of copyright and generative AI, you've probably heard a lot about cases that are pending about whether the use of copyright protectable works in the training of generative AI models is infringing or not, or whether it is covered by the doctrine of fair use. That is a really interesting question. I wish I had time to talk about that, but what I'm actually going to talk about instead is the question of what happens when you create something or when AI creates something. How does copyright relate to that? Not because the fair use question is not important, it's probably more important, but because there is a sort of set of questions and ideas I want to elaborate on that the AI, the fair use question really is kind of tangential to. So let's start a little bit with a kind of copyright. There we go. Copyright 101. So, copyright, for the very, very quick explanation of what copyright even is, for those who maybe don't know, copyright protects works of creative works, works of authorship, works of information writ large that are embodied in some form. So everything from an email I typed to my friend, protectable by copyright, to a Hollywood film, to fine art, photographs, all sorts of kind of creative things are protectable by copyright, meaning if someone infringes on that work, copies it without permission, makes a similar duplication without permission, performs a movie without permission, performs a play, they could be subject to liability. So very, very simple, basic explanation of what copyright is. But one thing that is also a requirement that we didn't really talk much about until these AI cases came about is that a copyright protectable work has to be authored. It has to have an author. It has to have someone who is a person who is kind of the causal agent behind it. Some people attribute this to the Constitution's IP clause, which specifically mentions authors. And there is a theory that implies some kind of human behind the scenes. That question has never been litigated, but historically, this is just how we have interpreted it. And the Copyright Office, which is the office that registers copyrights, you don't need to register your copyright to have protection, but it's a very good idea to. You get certain kind of more robust protections. You get a kind of like presumption of protectability if you register your work. The Copyright Office has always refused to register a claim if a human was not the author behind it, and noted also in the past, and this is something that has come up in the AI context, that if a mechanical process, a machine-based process produces something randomly or automatically, that too will preclude protection. This has come up in some cases, often involving things like nature, including this guy, Mr. Naruto, the monkey, who actually took this photo as a selfie. He grabbed the camera from a nature photographer, took the photo. The photo ended up on Wikipedia. Wikipedia basically said, well, a monkey took this photo, there's no copyright. The cameraman disagreed, tried to get it taken down. PETA then filed a claim as next friend for Naruto, the monkey, saying, well, actually, Naruto should own the copyright of the photo. And the Ninth Circuit basically said, sorry, Naruto, you need to be a human to have standing to pursue a copyright claim. The implication being you need to be a human in order to protect your work with copyright to be in general. The second image is of a garden. This is a famous Seventh Circuit case where the court basically said that a cultivated living garden could not be protected by copyright for several reasons, but one was that nature was sort of the author of the garden, to the extent we could think of it as like a sculptural work rather than the designer of the garden, the gardener, and therefore this also precluded copyright. So the courts and the Copyright Office have been grappling with how to apply these sort of background principles to generative AI. And the big case, the only real case that we have, is this case Thaler v. Perlmutter, which was decided by the DC District Court 2 or 3 years ago, and only very recently did we get a DC Circuit opinion. And these opinions were basically said the same thing, which is that an AI itself cannot author a work. So so ChatGPT, DALL-E, Stable Diffusion, they cannot be considered entities that themselves are authors of the work just because they are a bunch of a bunch of algorithms that can produce stuff that we might consider to be the kind of things that could otherwise be protectable by copyright. The real implication of that is that the owners of these, or the owners of these proprietary algorithms, things like that constitute these types of systems. And this was the case in this case. Mr. Thaler basically created his own generative AI system and said, I should be the author, I should be the owner of this work that was produced using the system because I created the system, I own it, and therefore it is essentially like a work made for hire for me. And the court said, sorry, you cannot, there is no authorship in this work. No one is the author of this work because a computer made it, and therefore there is no copyright here. Therefore, no one owns it. It essentially is in the public domain in the same way that works that are very old are in the public domain, the Mona Lisa, things like that, as well as other types of works that just don't have copyright protection. So this answers one question, which is, can an AI itself be an author? But this kind of isn't really like the most interesting question. The more interesting question is what happens when a human engages with an AI system as what we might think of as a tool in the process of creation. Does that create a work that can be protectable by copyright? Or do these barriers to protectability, this authorship requirement, does that prevent protection of these works as well? So the courts have not really dealt with this yet, but the Copyright Office has dealt with this quite a bit through a variety of review board decisions, as well as a recent report that kind of went through the state of play. And so I'm going to go through a bunch of different kind of cases and scenarios that the Copyright Office has dealt with to sort of arrive at a few principles. So first we have this question of what happens if I type in a prompt. I am a human, I am a kind of human agent, and I am a person who's choosing to type in a prompt. I envision the prompt, and I type it in, and then the generative AI system creates something based on that prompt. Is that sufficient to say that there is a human author that has created the thing? Different question than if the AI itself can be an author. Here we have a human that is engaging with an AI system to create something. What does that mean? And the Copyright Office has basically said, if all you're doing is prompting, it's almost definitely not enough. The process of prompting, even if it's a very complex process involving iterative changes to your prompting over time, what some people call prompt engineering, that alone is not going to yield a copyright protectable work. And the reason why is basically because of this garden case. So the analogy that the Copyright Office has drawn is that, just like a gardener may envision the shape of this garden or sort of the kind of flowers that might be planted, but ultimately it is a separate thing that is supplying the kind of creative stuff that makes this thing a sculpture or even just a beautiful thing. And so too here, if I type in a prompt, or in this case, if Mr. Thaler, the author of this, or the purported author of this work, typed in a prompt, there was no way he could envision exactly what he was going to get, because essentially the algorithm was supplying sort of the creative substance of the ultimate image. So even though he was directing it at a very high level, because the generative AI system was supplying sort of the creative meat of what we think of as a copyright protectable work, the work was not going to be protected. So prompting, text-based prompting, not enough to create a copyright protectable work. But that doesn't answer a bunch of other questions. So one question would be, okay, what if you use generative AI to get some images, but then you compile them and you add text, which is basically what a comic book is. So here we have a case involving a comic book where the images were AI generated, and we can talk a little bit more about specifically how the purported author of these images got to these images, because had they disclosed more about how they came about, perhaps the office might have been a bit more sympathetic. But basically what the office sort of knew at the time was that the images themselves were created by Midjourney. You can even see it says Midjourney at the corner of the comic book. And the purported author, Chris Castanova, compiled them, added text, created sort of a story involving the image. So the office here said, sorry, images themselves are not protectable, but we can give you some thin protection via the compilation of the images and the inclusion of text. So for those of you who've taken copyright, you may remember that the compilation of things, even things that would otherwise be unprotectable, can create a copyrighted work. We call it a kind of thin copyright because it doesn't protect all of the different individual pieces, it only protects the whole. So what does that mean in context here? If I were to take like this main page image of this person who I think kind of looks like Zendaya, but that might just be me. And if I were to take her face and use it in my own creative work, the author of this work could not complain because the individual images are not protectable. But if I were to copy the entire comic book, the full compilation, then they would have a claim against me because I've taken the entire thing. So not a great copyright, it's still something, but it's not the kind of copyright you want if you really want to make sure that people are not using your work without permission. Okay, so then we have a few other sort of different fact patterns. So one question is, what happens if you take an image, a copyrighted work or a creative work that you maybe own or that certainly is copyrightable, like a photograph, and you stylize it using AI. So here we have an example where this original photograph was stylized with instructions basically saying style this using the same sort of style from Van Gogh's Starry Night. And then we ended up with this output over here. Here you go, so you can see. And the office said this too is not protectable. Basically, based on the same logic that I've already explained, this creative substance is a product of the generative AI system rather than the author of rather than a human, and therefore it lacks authorship. I'll explain in a minute why I think this also requires us to understand that the output work, the AI generated work, really does not look very much like the original photograph. I think that's a key point here, partially because we have another example where the office actually was more sympathetic to this stylization argument. Here we actually have the same person who created the Zarya of the Dawn comic book, who created this little drawing. They drew it themselves. Clearly copyright protectable, but then used AI to stylize it. And the Copyright Office actually said this is protectable, at least the base image itself is protectable, and that would yield some copyright in the second AI generated image, provided the specific AI additions are disclaimed, are not included as part of the copyright. But ultimately, you have some protection in this output image based on the fact that the base image was protectable. How do you square that with this one? I think it has to do with the fact that this one, the output really does look like the original, whereas here there really is not much of there's not much similarity. So basically, sort of the copyright in the original can kind of carry forward and protect the output here. But again, only the sort of type of stuff that you would think of as protectable in the base image. So if I were to kind of cut and paste all the little roses and make my own thing, probably not an infringement, but if I were to take the entire image and copy it, that would be an infringement. Okay, and then we finally have the last example, which is, all these have like weird kind of pretentious names, single piece of American cheese, but here we go. So this has to do with the question of what happens if you are using an AI system that provides what we often call it as what's often called in-painting, a kind of iterative, interactive tool in which you can change aspects of the image in real time, sometimes using additional generative AI material, but you are kind of engaging with this in a highly iterative, interactive fashion. And initially, this image was rejected. It was submitted, I believe, by the creator of this specific in-painting tool because they kind of wanted to do a test case of whether they could get this registered by the Copyright Office. So initially rejected, but then they provided a video of the process by which they generated the initial image and then tweaked it and changed it using these in-painting tools. And ultimately the office said, okay, you can have a registration that protects, this image. Again, with this language of like disclaiming the truly AI generated stuff. I imagine Professor Stein might have some questions about what that actually means in practice. But we do have a successful registration in this case because this video was provided showing that there was kind of an interactive, iterative process that was not just, show me weird lady with 3 eyes and she's on her head. There was a much more kind of interactive human creativity that went into this image, into the selection, coordination, and arrangement of these various AI materials. So this is the state of play. This is where we're at with copyrightability. Unclear if the courts will agree with the Copyright Office's approach. My instinct is they probably will. The Thaler case that I mentioned, the DC Circuit case, they were pretty deferential. Copyright Office doesn't get Chevron deference back when Chevron deference existed. But even if, they still get a lot of respect from the courts when it comes to these determinations. So I'm not totally sure the courts are going to disturb this sort of status quo, which is basically that most AI generated things are not really going to be protectable. You will get some protection if you change them, you add things to them sufficiently, but the initial image, the initial text, not going to be protectable. So why does this matter? I mean, there's a lot of reasons we might say this matters, some of which relate to what does it mean, why we have copyright, why we might want to allow protection for certain forms of new creativity or not, why we might want to prefer older forms of creativity or forms in which humans are more directly involved. And I'm happy to get into some of those in the Q&A. But one area I want to talk about where I think this matters in a sort of more implicit and less obvious way is this question of disclosure. So what do I mean by disclosure? I mean, when do you have to, if you use AI to create something, when do you have to tell the public that you have done so? And there's no affirmative duty to do that. I mean, just like there's no real affirmative duty to say, well, I got an idea from my friend and then I wrote a novel based on it, or I used an editor, or I used a ghostwriter. No affirmative duty to do that. And so there's no independent area of law that would say, okay, if you make a comic book using AI, you have to tell the public I did that. You could probably claim that you didn't, and in fact, that you did it yourself. And the current state of play with respect to copyrightability, in fact, makes that a very appealing prospect. So why is that? Because if you are, let's say, a big movie production company, you really don't want to not have copyright in your work. And same is probably true for novelists, photographers, anyone who uses creative works commercially. Copyright is really important to making sure that you can monetize your work. Why is that? Because if you don't have copyright, anyone can use your stuff without permission, no questions asked. So if you're using AI and you're at all worried about not getting full copyright protection, there's a pretty strong incentive to not disclose what you are doing to the Copyright Office as well as to the public. So why do I say both? Because you kind of can't disclose to one and not the other. And that, in fact, was the issue with these two works. So neither of the purported authors of these works did not actually disclose their use of AI to the Copyright Office, but the Copyright Office got wind of it because there were social media posts and things like that talking about how they had used AI to create these works, and that was the reason why the works were ultimately rejected by the Copyright Office. Conversely, if you get a copyright registration, it says very clearly, if you used AI, maybe you're getting a thin registration that covers a compilation. It's going to say, all of the stuff that is not included in the registration. So you really can't do one without the other. So I think this actually probably creates a pretty strong incentive to hide the use of AI from the public. We're probably already there. Maybe we'll be there in the future, partly because right now, it's not that hard to tell when something is like a little AI generated or totally AI generated. It has like the mid-journey look that people talk about, but that's changing pretty quickly. So like this is from a text to video app. I forget the name of the app, but like that's a pretty realistic looking parrot if you ask me. And I think we're already at the stage where human eye cannot alone detect whether something is AI generated. Certainly for text, we're at that point. So disclosure, I think, deeply linked to the question of copyrightability. But then there's another question of, why do we care about disclosure? So this is the subject of the paper that Professor Roberts mentioned. I'm not going to go into the full argument of the paper, but I want to just close by talking through some of the reasons why I think disclosure matters to a lot of different consumers. So one reason is because when we choose to consume a creative work, when we choose to watch a movie or look at a painting, we're not only doing it because, or many people at least, are not only doing it because they like the movie or think it will be funny or think it will be entertaining. They're also doing it because it reflects something that they like about the process by which it was made or don't like. And this is something that happens in a lot of areas of commerce. So when you might not be able to tell the difference between ethically sourced coffee and non-ethically sourced coffee from the flavor of the beans, but for many people, they choose to engage in consumption choices based on ethics, based on what they believe to be sort of the responsible place to put their money. And I think a lot of those ethical questions have been, or not the same ones, but similar ones have been implicated when it comes to AI. Should we care about the broad displacement of labor in certain creative markets by AI? Should we, is there sort of an argument for responsible consumption that avoids AI generated material? And in a world in which disclosure is not, in a world in which there's a lot of incentives not to disclose, it's increasingly hard for consumers it would be increasingly hard for consumers to make that kind of educated, ethical decision. Relatedly, we have kind of like a much more nebulous concept, but one that I think is still important, which is authenticity. And we see this in a lot of areas. Why do people care about like artisanal handmade soaps and beers and things like that? You may not be able to, maybe it's because the flavor is better, but even if it's not, or even if you can't really tell, there's still something about the human touch that that people value in their consumption choice. And with art, that's I think particularly true. I think there's something about the idea of a person creating a painting on a canvas versus someone typing in, show me a dog in the style of Van Gogh and getting a dog in the style of Van Gogh. That changes the way in which we would relate to that piece of art. And in the paper, I spend a lot of time talking about sort of like the aesthetic theories behind this and why they maybe matter or not, but I'll leave it there for now. And then finally, there's something I think similarly nebulous, but also important, which is we often care about the specific person who created the thing. So this is the fake Drake, fake Weekend song from I guess a year or two ago that some of you may remember, where it was a very compelling AI generated mimicry of their voices. And this is sort of an interesting category because you would think that like the artists themselves would care, that would kind of create like a trademark, right, a publicity problem, that they would say, well, like obviously Drake doesn't want all sorts of songs masquerading as him because he would lose money and credibility from that. But there is an interesting question about what happens when, I don't know, maybe not Drake, but some artist decides, well, my personal brand is so valuable that I can just, outsource my future creations to an AI and essentially license my brand name, license my name and likeness to AI generated art. Art is the public losing something there because you think you're getting a Drake song or a Taylor Swift song, but what you're actually getting is a AI generated song that Taylor Swift had. Not that Taylor would ever do this, but someone less responsible. You're actually getting an AI generated work. And in fact, there have been YouTube has been experimenting with licensed uses of voices and image and licensed uses of voices. And the question there is, does the consumer have an interest in knowing the provenance of this work because of their relationship with their artist, the sort of subjective meaning that many people derive from a kind of fan-based relationship with an artist. Okay, so some reasons why we should care. I'm happy to talk at maybe during Q&A or my discussion with Professor Stein about what we can do about this, but I'm gonna leave it there because I've already given you a lot of information and I'm sure there's a lot more to talk about.
Your turn.
Me.
It's one.
Amazing. Oh, this is so fun.
It should be on the camera, right? Camera's what
Oh, just for the Zoom people, so there we go.
Yeah.
So we had the wonderful opportunity to spend like the past couple hours with me asking questions. So I'm gonna try to pick my my favorite little bits to zoom in on here. I think one of the interesting things that's showing up throughout the whole discussion is there's a little bit about a human creativity here. And then it seems like there's also a little bit about the idea of, for lack of a better phrase, the sweat of the brow. That there's like something about the value of art that comes from the fact that people like learned how to make that art. And I really see that in the examples of American Cheese and Zarya of the Dawn, where if you read over the notes, the Zarya of the Dawn project is essentially made using the same process, but their disclosure to the Copyright Office was in text rather than this video that showed how much work went in. And so it's surprising that they came to different results. And so we talked a little bit about your work in relation to the work of Katrina Geddes, who's written about this concept called semiotic democracy, which is the idea of being able to see yourself in art, where the barriers of entry to become an artist are high. You have to do a bunch of work and have the resources to get to do a bunch of work to get good at painting, right? Like that means you have a studio, it means you don't have like whatever stuff happening in your life that would stop you from spending hours and hours painting every day and getting good, which like might be associated with being a member of an underrepresented group. And so if you wanted to see people like you in media, maybe something that lowers barriers of entry is desirable. And so I guess kind of leaving you an open-ended room to react.
There's a lot there.
Where do you feel about effort and the role of effort in art?
Yeah, so I will agree that I think sweat of the brow or effort, which is another way of saying sort of effort or labor, which is a concept that used to have more of a role in copyrightability, but supposedly done away with in favor of like an originality standard. That maybe is having a bit of a resurgence here. Doctrinally, the way that the Copyright Office has tried to rationalize it is not so much about sweat of the brow, but about this sort of foreseeability, predictability thing. Like if you are, who is supplying, like part of the way in which we can know that someone has engaged in authorship is if they can kind of like envision something in their mind's eye and like make it real on a canvas or on a page. And the ways in which these generative AI systems work don't really follow that normal process. So again, if I type in "show me a dog," or if I type in like a really complicated prompt, I'm probably not going to be able to envision what I'm going to get in the same way that even someone like Jackson Pollock could envision what they were going to get, even though they were also relying on sort of natural phenomenon and nature-based things. That's where the line, that's a line where things start to dissolve. So, do I think that like sweat of the brow is the animating principle here? Maybe behind the scenes, but I also think there are more like sound doctrinal principles, principles that are animating this distinction. That doesn't necessarily answer like the sort of normative question, which you got at towards the end, which is like, is AI about democratizing art And by fetishizing labor or even foreseeability, are we excluding lots of people who would otherwise be able to be creative? And you know, I think there's an argument there, but I think, and I'm all in favor of democratizing art, but I also think that art and copyrightability are not necessarily coextensive. I mean, just because you can't get money from it, i.e. stop people from copying it and charge a royalty to people who want to use it, does that mean you haven't created art? I mean, there's a lot of art, there's a lot of conceptual art that's probably not copyrightable. So like the banana on the wall, I forget the name of the piece, but certainly not, almost certainly not copyrightable. Does that mean that that artist is not engaging in art? I think not. You know, Jackson Pollock is copyrightable, but it's sort of like a bit of a weird. It's like a threshold case. I'm sorry, it's like a kind of order case. Still certainly art. So, you know, I'm not sure that copyrightability is essential to semiotic democracy necessarily. I don't want to keep going. We can maybe get into this later, but you know, there's also trade-offs to allowing copyrightability for this type of stuff, which I'm happy to talk about, but I'll turn it back over to you.
You want to queue up that question?
Yeah, I just felt like I was going on. Although it was a very open-ended question.
It was. Yeah, so I think I want to dig a little more into this and just get a kind of where do you think the lines are, since there's a lot of test cases here and you've spent a while on it. I find the Van Gogh style transfer case really interesting because it's Van Gogh. And we'll talk, I think we're probably going to talk a little bit about some of the just fundamental copyright concepts that this makes vivid. But there's a hypo that I think is the natural hypo to have with the Van Gogh style transfer, which is what if I, instead of having a Van Gogh image, had like a camera pointed at a canvas that I was drawing on myself and watching in real time as my style is transferred. Right, like where is I'm trying to find that edge case that's like, oh, that would give you all of the copyright in the original image. Or in the resulting image, because I'm putting enough in. Where do you see that new Jackson Pollock-esque line existing in the digital realm?
Yeah, that's a good question. It would maybe, I mean, this is get really in the weeds, but then the question is, does style is not copyrightable. So the extent to which your style is transferred doesn't necessarily mean that you've created a derivative work. Like someone else could use your style too, even if you're creating it in real time. So the fact that Van Gogh is in the public domain, I think, is less relevant in that case than you might think. If that answers your question.
The hypo I was trying to get at, or the concept I was trying to get at here, was introducing more labor while not introducing more opportunities for copyright.
Introducing more labor without.
Right, style isn't copyrightable. So in theory, my work shouldn't matter. Right,
whether it's a Van Gogh or not.
Yeah.
What I think the Copyright Office has landed on is that it's really much more about the initial copyrightable image and its kind of visibility in the outcome as a sort of classic derivative work, where we often think of, you know, it needs to be similar to the original in a certain way to have basically say that the copyright owner can stop the creation of derivative works, of works involving the same character, the same images, the same text, things like that. So yeah, but then your question was like, where could we, based on the current sort of state of the doctrine, where could there be like more opportunities for protectability in the use of AI, or
where do you think that line is?
Yeah, I kind of like the Copyright Office's line, which is much more about the distinction between a text-based prompt and everything else that you would do with AI. So by, I think, allowing like the American cheese thing, what they're basically saying is like, if you're using AI in the ways in which historically we've like understood, you know, Photoshop to be used, kind of classic examples of like digital artistry that requires some kind of human-based manipulation of like a digital canvas, then we're going to be okay with it. It's a little bit similar to how they've thought about the stylization. So, you take something that is protectable and you stylize it digitally, we're gonna be okay with that. But if it's truly like ex nihilo, I type in a prompt and then something appears or text appears or an image appears, that's where we're gonna draw the line, even if that prompt itself was very complicated. To me, that makes sense doctrinally. I think it also makes sense normatively from the perspective of transparency, from the perspective of sort of like copyright incentives. Doesn't really make sense from, I think the article you cited by Katrina Geddes would probably disagree with that. Would say that, the real metric is whether a person is being creative. But I kind of think that can't be the only metric for a variety of reasons I'm happy to get into, but.
Well, maybe I'll switch gears
Okay.
so that you can, on disclosure.
Yeah.
If I'm knowingly using AI, if AI is a main part of my process, I can imagine needing to disclose. It's interesting. I don't know if the Copyright Office requires me to disclose all of my methods or production. Interesting to single one thing out. What happens as AI becomes more integrated into other forms of production in a way that I might not, as an artist, have immediate knowledge of where AI fits into my.
Right. Yeah, so on the first point, the Copyright Office now requires disclosure of the use of AI because there's such a line between protectability and not. They don't require other disclosure of other creative processes. Maybe they should. The analogy that people often raise that I think is interesting is like if you're a Dale Chihuly or a Jeff Koons, and who are both fine artists who basically like kind of conceptualize projects and then have a bunch of like people do the work for them. So Chihuly is it's a glass blown sculpture. Koons, it's like a whole bunch of stuff, but Koons in particular is known for this, never like touches the canvas, never touches the work, basically. It's just he's purely the conceptualizer guy. Why would he be able to get a copyright in one of his sculptures, like these shiny balloon animals you may see in fancy office buildings if you ever work in a big law firm, because that's where they seem to always show up. Why should he get a copyright in that? And why should he not have to disclose the use of labor? There's a good question there. I think the answer is that process is more cognizable in sort of bread and butter ways in which we understand creativity to happen and also copyrightable creativity. So it's a little bit more like the Jackson Pollock example. The idea that you are what copyright was called like the superintendent of the work, that you are conceptualizing it but having other people flesh it out is not like a weird concept in copyright. It's sort of how films happen, and that is just sort of that I think, at least according to the Copyright Office, is fundamentally different than having a sort of black box algorithm produce stuff that when you have no idea where it's going to appear, what's going to appear. The counter argument would be like, how is it that different? Like Jeff Koons maybe probably doesn't know exactly how his army of assistants are going to actualize his idea. He's conceptualized it at a high level in the same way a detailed prompt engineer conceptualizes something at a high level and then has Midjourney flesh it out. So I think that those are like the harder test cases. I don't know. I think those are the cases that are going to give the courts the most trouble. Did that answer your question?
I think it did.
Okay.
I think it also gets into the other thing I wanted to.
Oh, disclosure, right.
Yeah.
It was more about disclosure, but let me.
It is,
Yeah.
but I'll join you on this journey.
Okay.
Because we're getting into means of production.
Yeah.
This is an interesting, I know we didn't get into the paper, so I won't go too deep, but you're doing something interesting here, which is different than how, unless Professor Roberts corrects me, trademark thinks about disclosure of source. In that if I had a trademark, I'm just saying it's my brand. I'm not saying necessarily something about my production. It's
Right.
And it seems like you're proposing something different, copyright to kind of go a different way.
Yeah. Yeah, I think I am, and I think that's partly because copyrights cared about it in a variety of, to the extent we care about originality, as coming up with something by yourself and not copying it. We've always cared a little bit about the process by which someone comes up with a new creative thing. Idea expression a little bit, but I think it gets more to the ways at least from my perspective, I'm much more interested in the ways in which kind of consumers care about this. And I think people do really care about knowing that the thing that they are consuming was at least mostly the product of like another human mind, rather than maybe a little like from a very high level the product of a human mind, but mostly the product of of a machine. And I think that really changes the ways in which we understand sort of art. And the analogy that people often raise to me is like a ghostwriter. Does it really matter if you enjoy Prince Harry's memoir, if you really care that it was ghostwritten or not? And I think the answer is like you actually probably sort of know. I mean, I think everyone kind of knows. There's like a bit of a cultural conceit in which we understand that certain things are ghostwritten. There's actually been really interesting kind of ethical theory, aesthetic theory work done about not ghostwriting, but what happens when someone pretends to be from a marginalized community or from an experience that had a set of experiences that they didn't actually have, and they write a book that maybe without sort of saying directly, let's say, I am a Native American and I'm writing a book from the perspective of a Native American, even if it's fiction, but they kind of imply that they themselves are building on some kind of set of personal experiences to create that work. And it turns out they didn't. I think we view that as like the crossing of a cultural, aesthetic, ethical red line that becomes problematic in a way that like a ghostwriter isn't. And I would analogize like many forms of undisclosed AI as closer to that, where you might believe that there is a human mind that created like the plot of this novel, perhaps based on their own experiences, perhaps not. But in fact, it was the product of a bunch of algorithmic decision making. I think that would actually change the way in which we would understand certainly the value of the work, the ways in which we wanted to engage with the work. So that's sort of the normative perspective I'm taking here about one of the many values of disclosure. I think that is the value of disclosure that I think resonates, at least from a sort of more artistic perspective and not from a pure like copyright perspective.
Yeah, it's an interesting departure from the normal like introductory account of the areas of IP law, where you'd say copyright is about an author's right.
Right.
And trademark is about consumers' rights. And it seems like you're doing a very
This is my next paper. Consumers and copyright. So thank you for teasing it.
I didn't know that. That sounds exciting. So that's still an interesting reframing of sort of the normative justifications of copyright.
Well, I wouldn't say it's a reframing of the normative justifications of copyright. I think it's like a set of additional normative justifications for transparency in which copyright's like implicated. But I'm not actually saying copyright should be like the means and ends of transparency. More that, and this I get into this in the paper, that copyright's already sort of implicated in this because copyrightability creates incentives to disclose or not disclose. So we have to sort of recognize that when we draw copyright lines, we're also going to be affecting disclosure. But I'm not saying, I don't think I believe that the reasons why consumers want to consume human-made work should itself be the reason why we should not recognize copyright in machine-made works. I just think we have to be conscious of that how we draw that line is going to affect that other sort of policy problem.
That makes sense. So I think I'm gonna do one more question and then we'll open up. So the last thing, we were talking a bit before this talk about some of the fundamental issues in copyright that get exposed through this investigation, especially in the way that things within the public domain get incorporated into works or don't in terms of their production. So I'm trying to think of the analogy that would make the most sense here. I know we talked about one of Lisa cases. But I guess I'd just like to hear a little bit about the economics and the idea of the relationship with the public domain and the private domain changing with AI.
Yeah,
especially recency.
This is great. This sounds like a question that you would tee up for me because I have many thoughts. It actually wasn't one of the things we really talked about. But so this is the first. So AI, I think, creates. It's assuming that the fault lines stay the same, and that a lot of these works are just inherently outside of copyright. So it's sort of the first time ever that like really valuable new works are not ever, but in like since the 1976 Copyright Act, first time that valuable new works are sort of starting out in the public domain compared to old works that maybe have some value but have lost a lot of value, or works that are highly highly tied to sort of obvious natural things like such that they wouldn't be that valuable to begin with. But now, I might come up like let's say, I always use this as an example, it's highly conceivable, but let's say like Fast and Furious Part 10, the screenplay was written by an AI. Because like you can kind of imagine, like ChatGPT writing a pretty good Fast and Furious Part 10, based on the being trained on the first 9. I don't know if there's actually been 9 movies, but you know what I mean. That would be a pretty lucrative screenplay. But if that screenplay doesn't have protection, it doesn't necessarily mean the whole movie wouldn't have protection, but it would certainly weaken the protection of the ultimate movie that was created. And there we have a situation where like a highly valuable work is either entirely or partly in the public domain simply because of this authorship problem or question. And that's never really happened before. And I think that's partly what tees up this problem of disclosure. There's never been a reason really to not disclose your methods to the Copyright Office because the stakes have been pretty low. I mean, it's generally really easy to get a copyright in anything. But now if the use of AI changes that and all of a sudden it's something that might actually be pretty lucrative if it was protected by copyright, you would lose protection if you disclose it, that changes the calculation. So, what to do with that is an interesting question. But I think it will create more situations in which we have to tease out the line between sort of like public domain stuff and protectable stuff in the way that we often think of as happening in substantial similarity cases. But for those of you who have taken copyright, in those cases we're often thinking about like were really old carpet designs included in a new carpet, right? But now we're going to have to think about was an AI generated cartoon character included in a Pixar movie, and how does that change what is protectable, what can be taken from that movie, and what can't be? And that's going to create a lot of litigation, I think, that will look similar to litigation in the past, where we had to sort of filter out public domain material from copyright protectable material, but the economic stakes are just going to be a lot higher.
Yeah, and that's an interesting echo from, we were talking about this, because software copyright often manifests the same thing.
Yes.
Where it's very hard to pull out the functional, the computer generated, the human generated creativity in like say a video game, where there's like a blend of all of them together.
Right, and we're going to see that happening more in other contexts. Another paper,
Just queuing up for future work, apparently. Let's open the floor and Zoom to questions.
Great. One of the questions I had, I'm seeing a related question from Howard Knopf on the Zoom, so I'm going to kind of try to tie those together. So one criticism I've seen floating around is like, as generative AI tools are increasingly embedded in what we do and how we make stuff, creators are going to lose track of precisely what use they made and when they made it. So like, if you think about someone spending a year making a short film, they might have reached for an AI tool when they stumbled with a visual transition or a chunk of dialogue or fine-tune a background sound, all these kind of minor uses along the way. Can we reasonably expect them to keep a complete accounting of all of those uses? Is there such a thing as a de minimis use of AI? And Howard asks, are there reliable tools to detect whether a work or parts of a work were created with AI? And are there reliable tools to detect whether works like a thesis or a law review article involves plagiarism or copyright infringement? So I thought those questions were of a piece. And what do we do with that kind of conundrum?
Yeah, great. So I think I'll start with the second part. So the answer is not really. There just are not really good AI detection tools in place. OpenAI was working on one but abandoned it. People are always trying, but as the AI gets better, it's harder to tell. So there's a lot of suggestions for sort of changing private ordering, changing of industry norms. So maybe so California recently passed a law that basically requires like a watermark to be embedded into AI generated content, such that you can then detect it because the initial content had some sort of little, not a visible watermark, but like a just sort of key that would let you or a fact finder, a court know that AI was used. How you can really force developers to do this is a harder question. And I think the answer is maybe that the market might enable it one way or the other. If there really is a market for non-AI generated stuff, then you might have some kind of certification scheme, watermarking scheme that becomes more feasible. But those types of schemes always have a lot of they're easy to cheat, easy to put easy to sort of fudge what organic means. That's always the classic example. So not totally sure how that would work. So that then gets this question of, what happens in a world where these lines like further erode. And I think I think that becomes trickier. The Copyright Office in its report tried to distinguish between like using AI as a tool, which is okay, in the same way that it's okay to use a camera as a tool, and the AI itself being kind of the causal element behind the creativity. They don't really provide a lot of examples of what it means to just use AI as a tool in a way that's totally okay, no questions asked. But the piece of American cheese, the Rose Enigma case, those two images maybe pinpoint some ways in which that could happen. Versus the pure kind of like the line might really just be between prompting, yielding something not okay, but iterative, interactive tools of the kind, again, that we're familiar with through things like Adobe Photoshop, becoming okay. But then, as like culture and creativity changes and those things become even more embedded in the creative process, I think the whole thing starts to fall apart unless there does become a quick and easy way to just tell whether something was AI generated on its, not on its face, but using some kind of detection software, or maybe the penalties become a bit higher and we scare people off from doing it. Just because there are a lot of disclosure regimes that people cheat on, but the higher the penalty, you tend to think the less of a chance that might happen.
So there's some interesting parallels here. On the AI detection front, there's like a weird technical problem, which is until 2018, the way you build an AI that generates images is you have two AIs, one of which learns to generate images, and the other which learns to recognize if it's an AI image or not. Right. And the better your recognition system is, the better your AI is. Right. Because they teach each other how to do stuff. Right. And this is always the puzzle with AI, is if you can tell me how to detect an AI image, you've also told me how to make my AI better enough that it won't be able to be detected by an AI image detector. Yeah. Because necessarily those are the same, two forms of the same problem.
And I think this is why OpenAI abandoned its creation of a detection tool, not because they couldn't, but because those resources were better spent making ChatGPT better, yeah. Right? Or making DALL-E better.
I will just, for the benefit of all the students and the people on the recording, if you directly copy paste text from the OpenAI website into a Word document, there are artifacts from the website that are recognizable as from the website and definitely not from somewhere else.
Good for students to know.
Some subset already know. But that kind of gets at, I think, the watermarking idea. And the thing that's always struck me as a little off, which are the examples you put on the slide, I realize I'm just stealing stuff from your paper right now, are all things that consumers would seek out, right? Certified organic, ethically sourced, and not the opposite, right? Not certified inorganic. inethically sourced. These coffee beans came from slave labor, right? Like they don't have that label. We don't have mandatory disclosure for that. And that's because if we did it the other way, then the lies from omission or just mistake become a little harder for consumers to trade on. Whereas being able to affirmatively show that your process is totally AI free or whatever it might be, becomes something that like doesn't accidentally signal things when you just are silent, right? The meaning of silence is relevant. The flip side is allergen disclosure, where we do have a mandatory disclosure for you to put like, are there allergens in this food?
Right.
And sesame oil is one of those. And almost every company just puts may contain sesame oil on every package. This happens a lot in California with all kinds of things.
Right.
And then it
flammable in
becomes,
California.
it becomes meaningless.
Yeah.
Because like everyone just, it's safer to say maybe it contains the thing.
Yeah.
And then you don't really have any information and then it's not useful. This attempt to disclose is not useful.
Yeah, this is the big argument against mandatory disclosure in
Mm.
general, and I think it's right. And I don't think mandatory disclosure would make a ton of sense here. The flip side, the sort of omission, the positive disclosure. If we were all like, if we all believe markets work super well, then if you don't see the organic label on food, you should assume it's not organic. And if you don't see the like ethically sourced coffee label on your coffee, you should assume it's not ethically sourced. So the market kind of, if you don't see, if we ended up with a no AI used in this movie certification, then you could probably safely assume that anything that doesn't have that does have AI. The question though is,
that's Lemon's market though, right? In that
Right,
like if
right.
if the thing that costs me more to do is the thing that makes my thing more valuable to consumers, I'm more likely to do it. Than if
Right.
the thing that costs me more to do makes it less valuable.
the thing that
Right, like if I have to go through the process of seeing if there's AI anywhere in my process, and if
Right.
it does, disclose it. And when I disclose it, my product becomes less valuable.
well, but I think the point, I think I think the difference though is that not every consumer will care.
Hmm.
Whereas like in the market for lemons, right, I think that's a big difference. So you're catering to a certain subset of consumers. The same way not every consumer cares about getting great coffee. I think that's a particular subset. But I do think it does create a lot of perverse incentives for changing the definition of the certification. I mean, this is the classic criticism. There's a criticism of affirmative disclosure, and there's also a criticism of certification that you just tweak the definition to cover more products so that you can have your cake and eat it too. You can use less expensive non-organic farming processes, but still have the organic label that gets you to a certain subset of consumers. So I kind of think that could happen here, unless there was some government regulation of the certification, but that requires legislation that is probably not going to happen. I think there's a question there.
I'm Michelle, I'm at 1L, sorry, I haven't taken copyright, so apologies in advance, but I'm curious with the case that you gave of the park example where nature was like kind of the reason why humans weren't able to trademark or copyright that work. Like considering the hypo of an AI tool essentially teaches a human, like via text, like you should paint a photo this way or an image in this way if you follow these steps. Like in that instance, a human would be manually creating it, but the AI would be generating the idea. And I feel like there are parallels, especially in other industries like biotech in regards to like protein formation. And I remember there was like a New York Times article I read recently where AI is being used to help reimagine drug use for different illnesses. So I'm just curious, like within the kind of connecting that back to what you said about Julie, for example, and Kuhn, where they are kind of the architects of the idea, but humans are creating the piece itself. Like, what would you think of copyright? Like,
Interesting. Like the AI generates the idea, but not human creates the expression. So that's actually that would be like a great example, because I think it's actually fine. And that's because of this weird quirk in copyright where ideas are not protectable, but expression is. So if I came up with like the idea for a flower like glass sculpture, that I could not say like no one else can create flower like glass sculptures like Dale Julie style. Just as a general sense, even if I was like, I have an idea for like a red flower glass sculpture, you know, with certain petals and certain arrangements. But once someone goes and like substantiates it and creates it, then that's when copyright vests. So if I asked, so I think the area where I've seen this come up more, people have thought about it is like, if I use like a screenplay thing that sort of helps me come up with a plot point, but then I go and like actually write the screenplay myself, where will would that be a protectable work? And I think it would almost be an easier case than the inverse, where you came up with the idea, but then the AI wrote the screenplay. And maybe that's wrong, you know, maybe that makes us feel weird. You know, I think there would be ways of attacking that copyright as well. If it is true that the AI kind of came up with the basic plot points in the AI, and even if you substantiated it, you know, you might say the plot points themselves were not protectable, but the specific text that you wrote was. But it actually would probably be an easier case for the Copyright Office, kind of counterintuitively. So it's an interesting, it raises a really interesting hypothetical.
There's a really weird edge of this too.
Yeah.
I'm not gonna try to say someone that'd be wrong, although probably the same guess. Which is there was a trend on some social media, probably TikTok, of like typing, write me the lyrics to a country, like writing lyrics and chords to a country song, and then performing it. And there's a really interesting copyright question there, because the recording is a separate copyright from the composition. But I'm not sure if the specifics of the composition as it's expanded out from the performance would itself have a separate composition copyright, and how you would separate those.
Probably not. It would be more like if I record a public domain song, I still have a copyright in my specific recording.
So we're winding up in the same place again, which is
Yeah.
This is like public domain that doesn't exist, and then when it comes into existence, it's immediately public domain as it comes out of the AI.
Pretty much.
Yeah, that's super weird.
Yeah. Yes.
Thank you for sharing. It's really interesting on topic. I'm wondering, like for AI, the higher quality the content you feed them, the higher quality they will generate. But if the AIs are trained on copyrighted sources, how to protect, you know, the original creators' rights in those writings? Like it takes like years of efforts to create those works, but it's just like being used in 1 second.
Yeah, this is really what the big kind of infringement lawsuits that I didn't really talk about get at, which is it, you know, should AI companies be allowed to train their models on these copyright protectable material? Is that unfair? Does it deprive the creators of you know, money from licensing that they would have otherwise gotten? Does it displace their work? You know, so like if ChatGPT can write a screenplay, that means a bunch of screenplay writers are out of work. And you know, the authorship question that I talk more, you know, about in this talk does sort of relate to that too. It's not something I really got at, but you know, there's an interesting question of like what happens to labor markets or kind of creative labor markets in a world in which there isn't great protection or there's very little protection for AI generated works. And what I think it does is it creates incentives for like big conglomerates and middlemen like record labels and movie producers and book publishers to still rely on human creators, because they wouldn't want to risk losing the full protection of copyright by using AI or too much AI. So the way back to the screenplay example, you know, if using AI to create the screenplay for Fast and Furious Part 10 would potentially harm the copyright of the ultimate movie, the movie producer is going to have a strong incentive to continue employing human screenwriters to write that screenplay. So what I'm trying to say there is, I think these questions about, you know, sort of labor displacement and human authors, it's not just playing out in the fair use infringement context, it's also going to be playing out in this authorship, copyrightability context. Yes.
Kind of bouncing off of that, back in February, there's Moderator to be Ross, intelligence back in 2021. And in that, there's like a partial summary judgment that it was copyright infringement to be taking that information. How do you plan to see that playing out, like through this discussion as we see cases like Anderson feasibility or like Getty Images one? How do you see that ruling maybe either foreshadowing what might happen there, or maybe not at all having an impact, but how do we then pivot that conversation? And when we look at the copyrightability of the data used within, the generative AI data sets, like how then do we grapple with the copyrightability of things that are generated?
Yeah, a lot of great questions there. So for those unfamiliar with this case, this was kind of like the first, not quite generative AI, but AI machine learning case that sort of asked, like, if you take copyrighted stuff and use it to train an AI using sort of machine learning processes, does that infringe or is it fair use? And the court in the District of Delaware said no. And it's the first time a court really squarely addressed that issue. In that decision, the judge was pretty clear that they did not believe that the facts of this case were entirely analogous to the generative AI systems. So the generative AI cases. So I think it does set a precedent that could be used. There's like, I think now almost 40 different ongoing litigations involving AI companies and rights holders. So we're going to get a lot of competing outcomes here. So yeah, that doesn't bode well for the generative AI companies, but there was enough maybe that distinguishable about that case, including the fact that it was really like two competitors. So it was like I think Westlaw and their sort of proprietary like shepherdizing process that was allegedly infringed by this AI company that was marketing its own. So that is not entirely that, that none of the cases really involve, like, the closest I think is like the Getty Images case, where you have like if generative AI image generators are good for one thing, it's generating like stock images. So like if like Getty Images is going to be put out of business by generative AI, like, to me there is a very clear like market harm argument there that makes it more analogous maybe to the Ross case. But if we accept what Judge Bevis said, we're going to have to like do this analysis from scratch based on the like highly specific facts, including the ways in which the AI model is trained and how they get access to the data and all sorts of other things for each of these specific cases. So it's going to be, I think there's going to be like circuit splits, and there's going to be dueling district court outcomes. Like, it's going to be lucrative for copyright lawyers for many years.
I kind of want to sidestep in here if there's time.
Well, there's another student.
This is somewhat unrelated, so if you want to go on your sidestep after, go for it. But I just had a question about like the I think about like certified organic stuff and how that like excludes certain people like who don't come from privilege, like especially like wealth from that market, and like now they have to, go towards, coffees that are produced by slave labor. So do you think like a certification scheme for art would further exclude people from like the art market and like access to, well-intentioned produced art, not really? Yeah.
It's an interesting question, because like I'm far from being like a free market maximalist. But if you were like an economist, you would say, well, that means like that if those people are being excluded from the organic market, there's like, that's a malfunction of the market, because if they're like, we should actually expand, we should expand the organic market. I mean, you're right, eventually we'll hit like the different costs of labor and production and stuff like that. But like the people who like even low willingness to pay consumers or low ability to pay consumers should eventually be able to find an organic market that kind of like works for them. But like where you're sort of getting at more is like almost like is more like the kind of artisanal soap model, right? Like if we sort of like fetishize this as like something that makes things just more valuable, like the human touch, are we going to turn it into something that is like a way of signaling, not just like something that's a way of signaling like luxury, right? And is that going to create this sort of maybe problematic bifurcation in the market where, you know, if you can afford to watch a human-made video, great, you know, movie, great, but everyone else is going to have to settle for like the knockoffs, right? And that's, I think, yeah, I think there's a risk there. I'm not sure that risk, yeah, I think there really is a risk there. I'm hesitant to say that risk like would outweigh the value of disclosure generally. The other thing to consider though is that unlike organic food, which purportedly maybe requires more money to create, like the difference here is that AI stuff is going to be really cheap regardless because or should be really cheap regardless. And if it's not, because it doesn't really require anything to create except an AI model. And if it's not, it's already kind of like inflated. So on some level, like it makes more sense for human-made stuff to be expensive here than AI-made stuff. And if that, if that leads to some kind of like cultural or social valence being added to that, I don't know, I have to think about that more, if that's like inherently a problem. Or if it's just, yeah, I have to think about whether that's inherently a problem. Essentially the answer is kind of like, if everyone was like, I don't want the cheap AI stuff, there would be no market for the cheap AI stuff. So you kind of have to assume that people are going for the cheap AI stuff, not just because it's cheap, but because they are kind of cool with it. And if they're cool with it, then that just might be the way the market.
There's an interesting analogy to movie theaters.
Yeah.
In that like very few AAA studios are making non-action films anymore. Because the market for going to the movies to see things is different now. Watching movies at home is a sufficiently better experience and a sufficiently cheaper experience that like you're not going to go watch an art movie at a theater, or at least not enough people are to justify paying for that. Not the first time that's happened. People used to go to movie theaters to watch the news. If any of you have taken antitrust, you might remember those cases because they've come up there.
Yeah.
With the oligopoly cases. There's another interesting thing here that I'm not sure if it shows up, but it shows up a lot in the organic labeling, which is the idea of integrated supply chains. So you're in my scholarship corner now, which is this idea of content delivery is going to make a big difference, right? If YouTube has a little toggle on it that's like AI generated, not AI generated, and most of the AI generated stuff is crap, even if some of it's good. And so to get into the supply chain you want to be in and reach the markets you want to be in, you have to conform. You're going to see forced conformity. So like National Pork Products 2 summers ago, the US Supreme Court is combined with an egg case that's exactly this, which is California required means of source for eggs that all eggs are cage free, forcing Arkansas and Wisconsin to like move towards egg free or cage free egg production because like the railway goes through California and there's no way to like split out the eggs because they look the same. And so it just like pulled the whole industry to one spot because it wasn't tenable to reach all of the places you wanted to reach in the other spot.
And raise prices for consumers.
It raised prices significantly for consumers. Eggs are expensive in the US.
Well, for others.
Yeah.
I have a question on Zoom I want to jump to, Preston.
Yeah.
Hey, this is super interesting, and I really appreciate you guys coming and speaking about this. I just responded to a question 2 times ago. I am in favor of there being no ethical slop. And we've talked about it a couple times, but I think it really helped to reinforce the idea that like the cost saving of AI is going to come out of like the labor of artists. Like I'm very skeptical of the idea that savings that companies are going to get are consumers. It's not going to make media like less undercut. Like it's problematic for copyright, and copyright in a lot of ways will offend a lot of artists have for about artists already get paid and how like
Yeah, we're
thin
losing you a
those
little.
are.
Preston, you're breaking up a
Oh,
little.
But
sorry.
I think we got the point, which is a good one. Which is that why would a movie studio pass on the savings from the use of like an AI screenwriter to consumers when the reason why people gravitate towards movie studios is because they believe it like represents a certain kind of like quality, stamp that is really sort of the value that the movie studio owns, and they, and especially if I think the only reason that prices would go down is if there really was a way of meaningfully knowing whether AI was used, and there was a significant market that was willing to pay more for AI-free content and non-AI, and then in order to reach consumers, movie studios would have to lower their prices. But movie studios would not, certainly in a world in which disclosure is like obfuscated, which is the world I'm most worried about. There's no reason movie studios would pass on their savings. And I think we would end up just with artists with human laborers and artists suffering without any reduction in prices for consumers. And then to me, that's kind of the worst of all worlds. There's a question back there.
All right, last question.
My name is Reem. I'm an LLM student. And I've been very passionate about AI, and especially from the consumer side. But generally talking about this, we're here to talk about use and disclosure of an IP. I think it's so hard to get there because we have so much other fundamental questions that we are trying to answer here. And I feel like, I think we are in a battle with, we are taking an aversion towards this prompt versus the labor in copyright. And I feel like copyright is basically traditionally shaped by the practical concerns rather than deep philosophical questions about origin and or creativity or authorship. So my question is that, is it time for like copyright law to evolve, to recognize the creative effort that goes into crafting prompts, rather than focusing only on the outcome? Because that's a Jeff Kuhn versus Chile question, right? So is it because I think we are not focusing like prompt. If I give a prompt to this entire class, right, think about something, and they come back with their work, they're going to come back with the questions, that creative questions that they're asking.
Yeah, it's a great question. So the way I think about this is, I think you're right that copyright is now, that AI is forcing copyright, and this is what Professor Stein sort of mentioned as well, to grapple with some of these like basic inconsistencies in copyright law. And there's two worlds I think we can go in, and one is to sort of like one is to maybe look backwards and look at all of the inconsistencies that we've allowed to exist. So one might be, why should Jeff Koons be able to claim copyright over works that he never physically touched with his hands? And there is a doctrinal, that as I mentioned, there's a doctrinal way of saying, okay, that is one scenario, AI is another scenario. But we could go back even further and say, like, why are photographs fully protectable in the way that they are? And some people might say that all the way back to Burrow Giles v. Cerrone, we've been a little bit permissive in saying that, like, simply because someone literally presses a button, which is now the way photography works, that creates a sort of presumptively copyrightable image. Or we could kind of go the other way and say, we've allowed photography, we've allowed Jeff Koons for a variety of reasons. Is prompt engineering all that different? Are we just expanding the ways in which humans are creative, and all of the attention to like foreseeability and the nexus between like the human conceptualization of the work and the actual outcome is just kind of semantics, and why should we care? I think I'm a little bit more in favor of the moving backwards. I think like we were a little bit over-inclusive when it comes to copyrightability, and like maybe AI is gonna, I'm not saying that photographs shouldn't be protectable, but maybe this will yield a bit of a reckoning about the kind of stuff that we have sort of said, no questions asked, protectable. And that's partly because I think that we probably have been overly protective, and that there are good reasons to, not put everything within copyright just because it seems like a creative work when it actually wasn't, when there are actually significant questions about how it was created. But others disagree, including this paper that Professor Stein mentioned by Katrina Geddes that really does argue that like culture needs a kind of culture needs like a wide standard for copyrightability, and that the expansion of art into kind of AI is good and should be recognized by copyright.
Thank you so much.
Thank you.